Hi, welcome to Agently. Today we are going to discuss regarding a recent update that is on 23rd. You can see date here, 23rd 07 2005 2025. There was an amendment of Model Building Bylaws 2017. So we have Bylaws 2017 on my screen. One side we have Model Building Bylaws and one side we have the amendment. So let us dive in and understand what was the actual amendment and where it is going to be replaced. I'm not a legal advisor, but how much I can and what I have understood, I have updated. So let's dive in and let's go back to my screen. So here, if you see, let me use a marker, highlight the points. Okay, so if you see the following further amendment of Karnataka Municipality Corporation Model Building Bylaws. So this is telling Karnataka Municipality Corporation Model Building Bylaws 2017, which the government of Karnataka proposed to make exercise of the power conferred by subsection of the section this particularly act and something and all it is there. Then after that, the notice hereby given. Then the objection, if you have any objection, you can file within the time period. So draft bylaws. This is going to be a draft. It is not an act. It is a draft for now. So it has been released on 23rd. So next month, if no objection, it will become an act. So title and commencement. These bylaws may be called as Karnataka Municipality Corporation Model Building Amendment 2025. This is called. They shall come into force from the date of final publication of the Gazette. Okay, let me clear this. Let us go to the next page. Yeah. So if we see here commencement, this we have completed. So this is the next page. Let me zoom a bit. Okay, to zoom we need. Yeah, it should be clear now. Substitution. Okay, substitution of bylaws 3.15.5 in the Karnataka Municipal Corporation Model Building Bylaws 2017. So what it is telling, we have to go to 2017 bylaws 3.15.5 and entries relating to thereto following shall be substituted, it is telling. So important thing here to notice, substituted is quite important to see here. So substituted is important. Let us go further. Sanction of model building plan. The application may apply to modify building plan approvals. So this is the actual changes which is going to be made, and this is the name. So let us go back to main. Let me select this 1 second. Yeah, let us highlight here now. Okay, so this is, if you see, this is the draft of municipality model building bylaws, as it is very clearly told here. If you see, let me clear this. Okay, here you can see the draft of the following bylaws, further amendment of Karnataka Municipal Corporation Model Building Bylaws 2017. So same thing we have here. You can point out here and see this one. Where is this? Yeah. So if you see here, this one, same thing it is referring. We have Karnataka Municipality Corporation Model Building Bylaws. So this is matching. So let us go further. Now we have to search which section in this, which it is told. 1 second. So in this it is telling 3.155. So let us search this option actually where it is 3.15. First let us see here which it is coming, where it is coming actually. 3.15. It is called as revocation of license. You can see this is matching to this one. Here it is written as 15. It is matching. Okay, so let us go to this one directly now. 3.5 it came. 3 we have to go to 3.15. Here we got 3.15 we need. 4 this is and 5. So actually what is this 3 sanction? It is 3.15 is nothing but sanction. Okay, so that is about building plan approvals. So here, so first we are understanding where it has to be replaced. So here, this is the point where they are talking about to replace substituted, as they have told very clearly, it is going to get substituted. Let me equalize, and it is getting substituted with this one. So 3.15.5 will be substituted. Instead of revocation of license, it will be given as sanction modified plan. So it will be given a sanction modified plan. So this is a different concept which is going to be introduced instead of revocation of license. To get revocation, that was like, what was the revocation? Let us read once so that we'll get a clear idea. The authority shall revoke any building license issued under provision of these bylaws. Sorry, yeah, is it tracking? Yeah. So owner has violated any of the provision of the building bylaws on the sanction plan or compound limits. Fresh sanction of building plans and occupancy certificate shall be taken from the authority bringing building within the framework. So it was not very clear. Now in this there is a very clear information in the new amendment, that is draft bylaws. So let us see what is this actually, and let us replace this one. Actually this whole text we have to replace. So this one we are going to replace with what is this again? Substituted. Yeah, this one. Here it is. Here we are going to get replaced. This one we are going to replace actually with let me pull out the details here. So where we are going to replace this 1545 here. Yeah, so here you can see this one. Okay, so here you can see 3.15. This is going to be replaced with this one. Now let us understand what is actually this. Now we came to know where it is going to be replaced and where it is going to come. So let us go and add this here. So we got to know where it is going to be replaced now. So let us understand now where it is, where we were studying the notification 2. So the 2 notifications. So this was notification 1, draft and amendment. Okay, I didn't read the second notification before. Let us read together only. Okay, this was the first one, substituted, and this is going to substitute 3.15, which we have understood what it is going to. Okay, now let us read what is the actual substitution. It is going to be sanctioning modified plan. So what is the modified plan and what they are going to sanction? The application, first one is the application may apply for modified building plan approval. So that means if you have already taken a plan approval, if you want to remodify it because you have deviated it. So modified building apply for a modified building plan approval. So if you want to change or else if you have deviated. So first one, under this first one, let us understand what it is telling. If the application intends to make changes resulting in more than 15% only, 15% deviation or such percentage as may be notified by government from the sanction plan in any or all the following, namely. So this 15% is very critical to understand. It is mainly for setbacks, coverage or coverage. Only two things. If you see very clearly, it is setback or coverage. So it is the building, that is the plinth level or what you tell main concrete construction base foundation where you do know, that one they are talking about. Setback and coverage they are talking about. So 15% deviation, you should not confuse that 15% deviation is for total building. So that is what even I was confused. But if you see the statement, it very clearly tells it is only for setback and coverage. Only two things it is talking about. So if the application intends to make changes resulting in more than 15% deviation, such percentage as may be notified by the government for sanctioned plans in any of the following, namely that is setback and coverage. So 15% can be deviated. They are telling more than 15%. Okay, more than 15% if it is deviated, then the setback, and in the setback and coverage, then they can apply for a modified plan based on the requirement. Okay, what is B? What it is telling, if the applicant make changes which result in more than 5%. Now what is this 5% for? You have to be very carefully understanding on this part. 5% deviation or such percentage, more than 5% or such percentage as may be notified in government form or sanction plan in any of the following, namely FAR, floor aspect ratio or floor area ratio. So this is going to be a lot of less deviation, that is 5%. Even more than 5% you have to apply for a modified sanction of modified plan. That is, applicant may apply for modified building plan approval if there is a deviation of 5% also. So these 2 points you have to understand. First point is 15% deviation. If it is more than 15% deviation under setback and coverage, then you have to apply for a modified building plan, that is building sanction. Then if 5% increase or more than 5% of deviation in what you tell FAR, floor aspect ratio or car parking area, if you have done, then you have to apply for re-sanctioning or modified plan as per the understanding. Now what is the second telling? If the deviations specified, everything is going to replace only this one now, as we have discussed. If the deviation, how small it was before, you can see. If the deviation, if you see this point now, where it is, okay, 1 second, where is the pointer? Okay, yeah. So if the deviation specified in sub bylaws 1, if the deviation specified in the sub bylaws 1, so first one what we have read now, in that is made due to any error in setting out orientation of the building site or avoidable site conditions such as deviation occurs during the course of construction, the applicant and the professional or on record supervision shall intimate the authorities. Now what they are telling in this point, this is not that clear. Let me remove this, maybe it is better. Okay, so what this is telling about is if the deviation in sub bylaws 1, so if the deviation is by an error or setting out of the orientation of the building, it is by a mistake on the site due to any other unavoidable site conditions like dimension variation such as deviation occurs during the course of construction, applicant and professional on record supervision shall be intimate the authority. If there is a deviation due to any error in site or any issues based on a legal way, so then they have to record the supervision shall intimate to the authority. You have to inform to the authority. So this is going to be 2. So not much complicated. 2 is 3. The deviation specified sub bylaws may be regularized by, this is very important, may be regularized by commissioner only after sanctioning the modified. So if this deviation is there, the deviation which is specified in bylaws 1, if it is more than 15% or more than 5%, so both you have to see. You have to see the FAR and you have to see the setbacks. If both is having, it means both, any one of also, if it is having, you have to, then may be regularized by commissioner only after sanction of the modified plan. So this building can be sanctioned, means it is approved building only if modified plan is there. So now recording thereon the deviation after leave of fees as may be specified by government. So price is not yet decided. They will decide the price. Recording thereon deviation and after leave of fees may be specified by government. So it will be specified by government. Now important thing here, you can see, provided the regularization of a deviation under the bylaws shall not apply to the buildings shall not apply to the buildings which are constructed without obtaining any sanction plan. So this whole story will not be applied for the properties which has not been approved at all. So provided the regulations of the deviation, the regulation of deviation under this bylaws shall not apply to building which are constructed without obtaining any sanction plan whatsoever, and also the deviation which are made in spite of the same being specifically deleted or rejected in the sanction plan. So this point very clearly tells that if you have obtained unapproved, or your plan approval is not approved, or else it was cancelled, or else it was rejected, so they are not liable to apply for a reapproval or the modified sanction plan approval. So that means all the B khatas and unapproved properties can't apply for this reapproval of sanction plan which is unapproved. So now in future B khata, if they obtain the approval, then it becomes a different story. But for now, till now, there was no approval for B khata properties, so they can't apply for this remodification. It is only the properties which have already obtained plan approval and they have deviated. Like simple, if they have taken G+3 and they have deviated, you guess something around G+5, then the deviation starts there. It is more than 5%. And now if the plot area is 1200 and if you had to leave 1.5 meters or setback or something 1 meter setback, and if you have deviated that more than 15%, then you have to obtain a replan approval, as very clearly told, the deviation specified in the subject due to any error. This is different story. So here it is very clearly told, regularization of the commission only after sanctioning the modified. So it will be regularized only after the sanction of the modified plan. So they have to apply. There is no way to get their property regularized. Okay, so this was one. Here if you see, we have the same thing, but notification 2 it is telling. Let us read what it is. Even I haven't read this properly before. I thought only one notification. The draft of the following bylaws further to amend the Karnataka Municipality 2017. Same thing we have to refer. And everything is good to go. Then what was it? 2307 this is. And this is 2307. Both are same dated. Okay. And then this is same. Then draft bylaws to the title and commencement. These bylaws may be called as, okay, this is same thing. They shall come into force. Final publication. That is same. Then 315 model by building bylaws 2017 for 2 or 3 entries related to the following shall be substituted. That is same. Then this same, it is same. Then here B is same. Okay. 2 is again same. Everything is same. I don't know why they have written notification 2. So here we are going to replace, as you have seen, it is very clear that this is going to be replaced. So let us bring this and get it replaced. Let me select. Okay. So this has got replaced now with this. Then after that, you can see the continuation would be same. That is again, what is their next step? Execution of work on site. It is here it is qualification of competence. Different things start from here. So this is going to be replaced with this. So basic things what we understood from this is, it is very clear that if your property you have deviated at the time of setback, that is more than 15%. If you have deviated in setback, only then you have to apply for a remodified plan. And if you have deviated in the floor area ratio or car parking, then you have to apply for a remodified plan approval to be valid, like as they told here. Only after sanctioning the modified plan, recording thereon the deviation and after leave of fees, something like this, it is told very clearly that only then this will become a legal property. Okay, these two things. Then again, what is the changes? 5% we have seen. And properties, if they have any deviation reason by what you tell, it is reason due to like side dimension or confusion or something, then they have to inform that due to this confusion it has happened. Okay, now 5% it is very clear for floor area ratio, and 15% it is very clear for setbacks. So then can B khata apply? No, only the plan approved, which is approved already, like properties which is having an approval plan, only they can apply this reapproval of building plan. Rest no one can apply other than this. So that's all for information of this. There was one more notification recently regarding buffer also, a buffer zone notification, but I was not able to understand very clearly. I tried referring a lot of documents. Some middle information I have got, so I'm not sure on that. So let us see. I will get back on that also. So for now, good luck, agent clear, property analyst. Thank you.